The Law of Self-Defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. For Thursday, February 25th, 2021. Hard to believe it's this late in February already. Last show of the month. Coming in, folks, make yourselves comfortable. If you happen to be watching this live on our Facebook page, where we do broadcast live, please leave a comment with your city and state. Provides us with some geographic context for our comments during the show. And also, if you could click like and share so others can be aware of the show, that would be helpful as well. There may also be some kind of bell notification you can click on our Facebook page that will help keep you notified of our live shows, give you notice of those. That would be awesome as well. If you're watching this on replay, welcome to all of you as well. As many of you may know by now, this is the one piece of public access, open access content we produce each week is this weekly Thursday Law of Self-Defense News and Q&A show. By the way, for those of you who may be new, I am attorney Andrew Branca for Law of Self-Defense, the host of your show, and the attorney at Law of Self-Defense, LLC. So this is our one weekly show that's open access. Most of the content we produce each week is for our members only. Law of Self-Defense is largely a membership program. But we do make this one Thursday news and Q&A show generally available to help the world learn of us and what we do. And what we do at Law of Self-Defense is we do use of force law, period. We don't have a generalized criminal defense practice. We don't take clients directly. All our clients are other lawyers. We're essentially a legal consultancy to other lawyers who have clients charged in use of force cases. And what we provide is our expertise, analysis, consultancy to those other cases. And all we do is use of force law, by which I mean use of force in defense of yourself, in defense of others, in defense of property. We don't do DWIs. We don't do shoplifting. We don't do anything except use of force law. That's our focused area of expertise, and that's what we try to bring to all of you in this Thursday show. By the way, new for this year, 2021, this weekly news and Q&A show is also available as an open access podcast. This is separate from our normal members-only podcast, which is obviously available only to our members. But the news and Q&A podcast is available to anybody, and you can find it on all the major podcast platforms, including Spotify, Pandora, Apple Podcast, iHeart. I think I may have a little graphic here I can share with you with some of those links, and indeed I do. So you can find us on all the major podcast platforms that you might think of. And if you have trouble finding us on any of them, just go to lawofselfdefense.com/free podcast, and it will have links. Sometimes their search engines aren't very good, but it will have links to each of those platforms where you can find our podcast. So, with that out of the way, let's start with the show proper. By the way, in the show, as the name might suggest, the news and Q&A show, in the first half of the show, we cover some use of force items that I saw in the news that I thought would be interesting to share with all of you, explain in plain English some of the legal dynamics in those use of force cases, things to watch out for, to learn from. In the second half of the show, we do Q&A, meaning you folks ask questions and I provide answers. Now, some questions are sent in to us ahead of time, and any of you has the liberty to do that. Whether you're a Law of Self-Defense member or not, you can send your questions to show@lawofselfdefense.com, and we'll take them under consideration for inclusion in a future show. If you are a Platinum Law Self-Defense member, you have your own Platinum Q&A form for submitting questions directly to me, where you can guarantee to get those answered either privately or publicly in the show, whatever you might prefer. So, before we jump into the show proper, I am, of course, obliged to mention our sponsor of today's content, which is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. CCW Safe, in effect, promises to pay their members legal expenses if their members involved in a use of force event, and those expenses start big and get bigger fast, folks. For example, imagine a case where you were threatened, you displayed your gun, you didn't fire a shot, you didn't hurt anybody, and now you find yourself charged with aggravated assault with a firearm, typically a 10-year or 20-year felony if you're convicted. And if you're charged with aggravated assault with a firearm, you're looking at a retainer to your lead counsel on the order of $30,000 to $50,000, and that's just for pre-trial work, folks. That's not for going to trial. Trial costs on top of that. And if it's a killing case where you're charged with manslaughter or murder because you've killed someone in self-defense, you're easily looking at $100,000 or $200,000 pre-trial expense. Just multiply that for the actual trial. And if you don't have that kind of money stuffed in your mattress, just in case you're compelled to defend yourself or your family, it can be useful to have a financial partner standing behind you to make sure you have the resources you need to fight the legal battle the way you want it fought, as if your life depended on it, because really the rest of your life as you know it does. And that's what CCW Safe offers to do for its members. Now, there are several companies out there that offer similar services. Frankly, I don't think much of most of them. I've looked at all of them, as you might imagine, and I found that CCW Safe is the best fit for me personally. I'm a member of CCW Safe. My wife, Emily, is a member of CCW Safe. One of the biggest reasons I favor CCW Safe over other similar offerings, by the way, is that many of those other offerings don't provide the level of resources you need for an adequate legal defense. If you're looking at a quote-unquote self-defense insurance offer that caps out criminal legal defense cost at $150,000 or $250,000, folks, that's not enough for a murder or manslaughter trial. Or if you're looking at an offer that says, hey, there's no limit to what we spend, but in fact, the only finances they provide for your defense in a murder trial is on, say, the order of $50,000, that's not nearly enough for your legal defense. So you want to make sure that you have the resources you need to fight the legal battle the way you want it fought. In contrast to those other CCW Safe promises to pay what the actual defense costs, period. No caps, no flat fee for the attorney involved. So read the fine print, folks. Make sure you understand what you're getting and not getting from any self-defense insurance type offer you're considering. Now, having said that CCW Safe has proven to be the best fit for me, whether they're the best fit for you is something only you can decide, but I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member of CCW Safe, you can save 10% off your membership at that URL, lawofselfdefense.com/CCW Safe, using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. And finally, something else I wanted to mention to all of you folks is that this week only, we're running an extraordinary sale on two of our most popular, most important courses. Our Level 1 core class, which is our full day course of instruction, either streamed online or in a multi-DVD class format, plus the state-specific supplement, another DVD, another 2 to 3 hours of plain English self-defense law content for any of the 50 states that you prefer. Normally, this combination is priced at $600. We're making it available for $150 this week only to those of you listening to this podcast. This is the lowest price we've ever offered these courses at, and you can get them, your choice, on either streamed online or DVD format or both. And the combination of both is that $150 offer, folks, 75% off the normal $600. So if that's of interest, after the show, point your browser to lawofselfdefense.com/show sale, one word, show sale, and you can take advantage of that opportunity. But it's only good until next week's show. So if it's of interest, I urge you to take advantage of it sooner rather than later. All right, with that out of the way, let's jump into our news items. The first of these news items comes out of New York, and the story is that of a grand jury, which is considering, so there was a use of force event in New York, in the Syracuse, New York area. A man shot his neighbor. The shooting looks like a legitimate case of self-defense, and it appears the man has not yet been charged with any use of force charge for that shooting. So far, at least, it looks like a good shoot in self-defense. Unfortunately, the shooting was committed with a so-called ghost gun. most of you in this audience are probably familiar with the concept of a ghost gun. It's a gun that's not serialized, produced by a manufacturer as a gun. Instead, it's sold as kind of a kit, typically an unfinished frame, often called an 80% frame. Other parts are involved in fully assembling the kit. Once you finish the fabrication of the frame, often involves drilling out some holes and some other important functional parts of the frame. So you're allowed to make your own guns in your home. There's no law against that, or at least there's no federal law against that, and there's no requirement that the weapon be serialized. So some people buy these ghost guns, sometimes just as a hobby type of thing, just to see what it's like to make their own. And in their state, it may be perfectly lawful to do so. This gentleman bought a ghost gun kit along with all the parts. And unfortunately for him, he lives in the state of New York. Now, I lived much of my younger life in the state of New York. And as many of you will know, the gun laws in New York are fascist. There's no other way to describe it. Likely, this person may have found it very difficult to legally purchase a gun in New York, although I would expect that to have been better in the Syracuse area than in the lower parts of the state. But nevertheless, he had this ghost gun, which he'd put together and he'd use to shoot his neighbor in what appears to be lawful self-defense. Unfortunately, New York State has laws against ghost guns. You're allowed, apparently, to have the ghost gun and all the related parts, but you're not allowed to assemble it into an actual functional firearm without having the arduous New York State permits required for legal ownership of a firearm. He did not have the permit. So while it appears he's going to walk on the use of force event, that simply wasn't criminal conduct, so there's no criminal liability, he's looking at 15 years in prison, folks, for having possession of the gun he used to lawfully defend himself. So I don't have an answer to this legal conundrum other than to say, if you live in New York and don't want to be subject to these kinds of laws, well, don't live in New York. It's one of the reasons I left the state of New York. But in any case, it's a reminder to all of us that your use of force itself could be perfectly lawful and legitimate, carry no criminal repercussions at all, but the circumstances around the use of force, such as possession of a weapon you're not lawfully permitted to possess, or alternatively having possession of a weapon on property that's posted against guns, so you're not supposed to be there with that otherwise lawfully possessed weapon, can raise legal liabilities for you completely independent of the use of force event itself, and result in a substantial period of time in prison. Again, this fellow who looks like he lawfully defended himself, in other words, he would have been killed or maimed but for having that gun. That's what makes his use of force lawful, and it appears it was lawful, despite the fact that he would have been killed or maimed but for having that gun. For having the gun, he's looking at 15 years in prison on a weapons charge, even though there's no apparent legal liability for the use of force itself. So, I should mention, folks, when we get to the Q&A portion, we do, of course, have some questions that were sent in to us ahead of time. I mentioned that earlier. You can send questions to us again at show@lawofselfdefense.com. I'll pop that up real briefly. That's just an email address. If you email a question there now, I won't see it for today's show, but we'll certainly save it and consider it for next week's program. So at any time, you can send us questions at show@lawofselfdefense.com. You can also, if you're watching live, this is not for the replay version of the show, a recorded replay, which we do make freely accessible. But if you're watching live, you can also put your questions in the comments. So if you're on Facebook watching this live, put it in the comments. If you're watching this on your member dashboard at the Law of Self-Defense website, you can put your questions in the comments there, and we'll scroll through those comments looking for questions before the end of today's show, which we try to end before the top of the hour. So just to remind you, I won't get to see the question until near the end. So if you post it immediately, I won't see it immediately, but I will review the comments for questions before the end of the show. So feel free to drop them in there at any time. So the next news story also happens to be out of New York, the Hyde Park area of New York. This involves a man who shot a neighbor's dog. Now, the man is claiming that, hey, I encountered the dog out in the street. The dog was threatening. I was in fear for my life, essentially, at the hands of this dog. And so I shot the dog to defend myself. Now, when you read the family's description of the dog, it doesn't sound like a dog that would be all that terrifying. The family that owned the dog describes it as being an 11-year-old mutt with 7 teeth that couldn't walk well. So, as is common in use of force cases, we have a disparity in the two competing narratives, right? The narrative of guilt, which is how the family is describing their helpless dog. There could not have been a necessity to shoot their dog. And the narrative of innocence by the shooter, saying, hey, I was acting perfectly lawfully when I was threatened with serious bodily injury by this dog, and that's why I shot it to defend myself. Now, there's a lot here that's wrong with the story. There are certainly circumstances in which shooting a dog to protect yourself would be lawful. And when you read the facts of this story, it seems unlikely to be the case here. And by the way, for all these news stories, folks, we have links to the news stories themselves in the text version of today's content. So we did this show not only in video form, not only in podcast form, but also in blog form as a written blog post, along with a complete transcript of the show as well, included in the blog, available at the lawofselfdefense.com blog, which is simply at lawofselfdefense.com/blog. Most of the content there is members only, but the content of each weekly news and Q&A show, the blog post, is available to anybody. And in the blog post, we do include links to all these news stories so you can better inform yourself about the more comprehensive totality of the circumstances of these events. So we don't really know what the circumstances were. The family says the dog was essentially helpless. There couldn't have been a reason to shoot it. The guy who shot the dog says, well, I was in fear of harm at the hands of this dangerous dog, so that's why I shot and killed the dog. What I wanted to touch upon here was certain aspects of this kind of case, shooting a dog in quote-unquote self-defense case, that's different than shooting a person in self-defense. For one thing, this is not a technical self-defense case. Technically, self-defense justification cases, the justification of self-defense involves the use of force against another person in self-defense. So when you read your state's self-defense statutes, or if you're in one of the handful of states that doesn't have a self-defense statute, but it's case law, all the references are to when it's lawful to use force against another person to defend yourself against some imminent unlawful harm. It's not when you're allowed to use force to protect yourself against some non-human harm, like a dog or other animal, wild animal, for example. Now, there is a legal justification available as a defense, a legal defense against a criminal charge for wrongfully shooting a dog. Obviously, shooting a dog is normally unlawful conduct. Shooting a wild animal, at least outside of the appropriate hunting season, is normally unlawful conduct. So it's normally criminal with criminal sanctions, unless you have a legal justification for shooting that animal. And the legal justification for shooting an animal, again, outside of the normal hunting season, but to protect yourself, would not be the justification of self-defense, but the justification of necessity, or sometimes referred to as the justification of lesser harms. The justification of lesser evil. Different states use different names, but the underlying concept is the same everywhere. And the idea is that, all right, you committed an act that's normally unlawful. That's a relatively small harm, but nevertheless unlawful. And your justification is necessity. In other words, yes, I committed that small harm, normally unlawful, normally carries a criminal sanction, but I committed that small harm in order to avoid or prevent a much greater harm. And under the doctrine of necessity, that commission of that small harm is justified because you avoided a greater harm as a result. And the classic example is somebody who sees a small child strapped in a car seat in a closed, locked car on a hot day all by themselves. And it's hot enough that it's clear this child will die in this car if the child's not rescued from the vehicle. So you break the glass of the vehicle so you can unlock the car, get the child out of the car, save the child's life. Now, is breaking the glass of the vehicle an unlawful act? Well, yes, of course, it's destruction of someone else's property. You're not normally allowed to do that, but your legal defense would be, sure, I committed that small wrong, breaking the glass, but I did it to prevent a much greater harm, which would be the death of the child. Now, there are conditions to the doctrine of necessity. One of them is that you can't have been the person who created the necessity. So if you happen to see a child and you happen to see an unlocked car and you threw the child in the car and locked it, so the child was then locked in, well, you should still break the glass to get the child out of the car, but you won't be able to adjust it under the necessity defense because you created the necessity. And that would be an exclusion from the necessity defense. In the context of an animal attack, normally it's unlawful to shoot a dog in the street. But if the dog is presenting themselves as apparently able and intending to cause you serious bodily injury, or from shooting a dog, really any injury, then you would argue the doctrine of necessity. Sure, normally shooting a dog is unlawful. It carries criminal sanction. But I did it to avoid a much greater harm, which is my being maimed or killed by this vicious dog when it attacked me. Of course, when pictures of the dog are shown in court, it better be a dog that looks capable of killing or maiming a human being. If it's a little Chihuahua, that's not going to look like much of a necessity defense, because it's going to look like your claim of the greater necessity to be avoided is either a fabrication or so unreasonable that it simply can't support the justification defense. That might be the problem for this gentleman here, right? If there's testimony that this dog was 11 years old with 7 teeth and couldn't walk well, and the jury buys that characterization of the dog, then it doesn't look like much of a necessity defense, because it doesn't look like there could have been a necessity to defend oneself against serious harm from this animal. So that's one issue. When you're defending yourself against an animal attack, it's not the legal justification of self-defense as we normally think about it, which is limited to defense against persons. It would be something akin to the necessity doctrine, doctrine of lesser evils justification. Another thing to think about is under the doctrine of necessity, the lesser evils, you're committing a small evil to avoid a greater evil. But especially in these dog shooting scenarios, a common charge that arises, and one which has been brought in this case as well, is not just whatever harm has been committed to the dog. In this case, the dog was killed, but the danger that's created by firing that shot to other people in the vicinity. Now, this would not arise if you were in the middle of the woods or something and nobody else was around. But if you're in a typical suburban street, there's other people, there's other homes, there's people walking around, for example. You fire a shot in that environment, well, there's no such thing as a miss, folks. The bullet keeps going until it hits something. So you fire that shot, you're creating a danger to everyone else in the vicinity who could potentially be struck by that shot. And of course, it's a potential danger of death, right, to every individual in that neighborhood. So now if you're trying to raise the necessity defense for having shot this dog, fired that round, for one thing, the round's unlikely to stay in the dog. So it's likely to proceed onwards until it strikes something else capable of stopping it. But in any case, the normal doctrine of necessity is I committed a small wrong to prevent a larger wrong. So I shot the dog to prevent being maimed or killed by the dog. But what if, in fact, your conduct didn't just avoid a small harm, it created a much larger harm. It created a harm of death to other people in the vicinity, a reckless endangerment. And again, that charge has been brought in this case. Very common in animal shooting cases for charges of reckless endangerment to be brought, completely independent of any use of force justification or charge, or any doctrine of necessity justification or charge, because you can't really use the doctrine of necessity to justify creating a risk of death to other people. That's about the highest possible risk there can be. That can't be the smaller risk in the doctrine of necessity balancing scheme, because, well, it's the big risk by anybody's standards. So I would not expect a doctrine of necessity to be very effective here. And folks, shooting dogs should not be your go-to strategy for defense against dogs. Dogs don't respond well to things like OC spray, lots of mucous membranes in the face of a dog. You don't have to kill the dog. It doesn't create a reckless endangerment of death to everybody else in the vicinity. I always urge people, if you carry a gun for personal protection, I do. I have my entire adult life. You also owe it to yourself to make sure you carry a non-deadly means of defending yourself. My preferred method of non-deadly self-defense is OC spray. Of course, a quality product, OC spray. And it works well against animals as well as against people. Of course, it's not magic. Doesn't always work every time. Nothing does. Guns don't either, by the way. But at least it's a reasonable fallback for non-deadly force self-defense. Here's another case. This one's out of Illinois, in which a man killed someone, claiming self-defense. And it looks like his self-defense claim may have merit. At least he hasn't yet been charged in the case. But it's another example of a case in which you can face criminal charges completely independent of the use of force event itself. And in this case, like the first one we mentioned, it's another gun charge. This particular individual was in a dice game. He was winning too much for the other players of the game. They decided to rob him of their winnings. They threatened him, it appears, with deadly force. He pulled out a gun, defended himself, killed one of his attackers. And it appears there's at least some prospect this was a lawful use of self-defense. As I say, this dice player defender has not yet been charged with any use of force charge. But what he has done is he's been compelled to take a plea agreement to a unlawful possession of a weapon charge because he's a convicted felon. So he's not allowed to be in possession of a gun, yet he had a gun. He couldn't very well deny having the gun while claiming self-defense for using the gun, obviously. So he's taken a plea on that, and he's looking at 5 years in prison as part of the plea deal just for the weapons charge, folks, completely independent of the use of force event. So something to keep in mind, especially for those of you, and I know there are some of you out there who may have a concealed carry permit where you live, where you normally spend your time, may occasionally find yourself traveling through states that do not recognize that permit and have more egregious laws. And you tell yourself, well, listen, I'd rather have it and not need it than need it and not have it. Just keep in mind, if it turns out you need it and you use it in that state where you're not lawfully permitted to possess it, you're in the same position as this felon in possession. You're in unlawful possession of that gun. Your use of force itself might have been perfectly lawful self-defense, and you'd still be looking at a 5 or, in New York State, as we saw before, 15-year prison sentence just for possession of the gun. So think to yourself, is it really worth it? And finally, I wanted to touch on another news story that comes back to a point I made last week. And the point I made last week in one of our news stories, and that news story was about a couple of states, North Dakota, Arkansas, I think perhaps one other, states that are moving to adopt stand your ground laws. Stand your ground, meaning, of course, that you're relieved of an otherwise existing duty to retreat before you would be privileged to defend yourself against a life-threatening attack. Most states, 37 states, are stand your ground states. It's the dominant, by far, position in the U.S. Only minority states impose a legal duty to retreat before you can defend yourself with deadly defensive force. And increasingly, states are, and this has been true for 20 years, there's been a bunch of states that have moved from the duty to retreat column to the stand your ground column. No state has gone the other way in the last 20 years at least. And that continues to be the pattern. So there's a number of states currently. Ohio just became stand your ground. Actually, it's not yet effective. I think it's not effective until April 6th of this year. But then Ohio will have become a stand your ground state. The law was passed and signed by the governor, but it takes a certain amount of time to become effective. Arkansas, North Dakota, one or two other states are in the process of have stand your ground bills in the legislature. And of course, there's always opponents to stand your ground. And it's always the same arguments that you hear about, say, concealed carry permits. Blood will run in the streets. People will kill each other because they bumped their shopping carts in the grocery store and all this kind of nonsense, which never happens, of course. And one of the things they do is they mislead with disinformation about the consequences of things like passing stand your ground. Sometimes they just blatantly lie about what the various crime statistics are as follows. But when they can't lie about the statistics, they use misinformation and disinformation. And a common approach here, they bring up every time there's a new state that's about to become stand your ground, is to say, wait. Look at all the other states that became stand your ground states. After they became stand your ground states, homicides went up. They didn't go down. Homicides went up. And of course, what we're all supposed to think is that, oh my gosh, when you pass stand your ground, lawlessness increases. The problem with that argument, folks, how they're deceiving you, is that there are homicides and there are homicides. And not all homicides are unlawful. And not all homicides are social ills. Some homicides are lawful killings in self-defense or defense of others. The intended rape victim who manages to kill her rapist in the act, she's committed a homicide. Would we prefer that she had been raped? The potential homicide victim who kills their attacker rather than get killed themselves has committed a homicide. Lawful self-defense. Would we have preferred that the victim of the attack have been killed? So when people talk about how numbers of deaths or gun deaths or homicides have gone up, they're either so stupid that they ought not be listened to, or they're deliberately intending to deceive you. So here's a news report based on a study. Of course, it was produced by the media, so the media is always anti-gun and anti-self-defense. But they're claiming, this is an Arkansas news outlet, they're claiming, hey, the Arkansas legislature should not pass this stand your ground bill because in other states, the number of people killed in shootings per capita increased by double-digit percentages in the years after lawmakers approved stand your ground laws in those states. In other words, hey, they passed stand your ground, those other states, and their homicides went up. Well, folks, maybe that was a good thing. Maybe the people who were killed, and let's face it, when we're talking about homicides, it all depends on who is doing the dying. Maybe the people who were killed were the bad actors. Maybe they were the criminal aggressors attempting to murder and maim and rape innocent people, and they were killed by their victims or by people stepping up to defend their victims. That's completely different than the homicides that are committed, again, of the innocent victims themselves. And why don't they say that? Why don't they say murders increased? Because, of course, by definition, a murder is a homicide that's unlawful, as opposed to self-defense killings, which are homicides that are lawful. They don't tell you that, folks, not by accident, but because they intend to deceive. Okay, folks, so that's all the news items I wanted to cover today. Again, I mentioned at the start of today's show that most of the content that we produce here at Law of Self-Defense is members-only content. Membership is dirt cheap at Law of Self-Defense. It's only about $0.25 a day to be a member, and I'd like to give you just a taste of the kind of content we produce for our members. So this is just content we produced since the last Law of Self-Defense show. On Monday, we did a blog post and video and podcast about a case in which a guest at a party shot the party host in the head with a 20-gauge shotgun pistol. Miraculously, the host survived, believe it or not. He basically fell down, got up, asked who shot him, and then walked off drunkenly to his own home. He did lose an ear, but he survived getting shot in the head with a shotgun pistol. And the gentleman who shot him said, well, I shot him because the homeowner was attacking his own wife, the homeowner's wife, choking her on the ground. And the interesting thing about this case is, of course, it's a defense of others scenario, right? The person being threatened was not the person who fired the shot. The person who fired the shot was defending a third person, the homeowner's wife, the victim of the homeowner's attack. And normally, a pretty classical framework for considering defense of other scenarios is that, hey, if the person who was being attacked would have been privileged to use deadly force to defend themselves, then other people are privileged to use deadly force on their behalf to defend them. That becomes awkward, however, if there's an enormous disparity of capabilities between the victim and the third-party defender. And in this particular case, the victim was the homeowner's wife. The homeowner was very large, much larger than the wife. The wife was much smaller. So it may be, while he was choking her on the ground, that her only effective means of self-defense might have been deadly defensive force against that choking attack. But that doesn't mean that the third party who fired the shot, that he did not have lesser than deadly means available at his disposal to stop the attack. He could, for example, have just shoved the homeowner over onto the ground so he was no longer able to choke his wife, as opposed to shooting him in the head. So that was one of the key issues in this case, and obviously we explore that in more detail in the blog post of that Monday. On Tuesday, we did another interesting blog post on self-defense immunity laws. Now, in Utah, and this is a picture of Moab, for those of you who don't know, beautiful part of Utah. Utah has a self-defense immunity law, criminal self-defense immunity, going through the legislature. And I commented on it because it's unusually well structured. So very often self-defense immunity laws are passed by states, and they basically say, hey, if the use of force was lawful, the person who used it is immune from prosecution or civil suit, depending on the state. But they don't provide any indication of what the legal procedure should be to determine whether or not the use of force was lawful or who should determine it or to what legal standard. It's all a black box. And in some states like Florida that passed self-defense immunity, they literally spent 20 years in the courts trying to work out what this procedure should be. Utah, on the other hand, provided a very detailed criminal procedure for determination of criminal self-defense immunity. So well worth stepping through that so you can see both the strengths of the Utah approach and the weaknesses of the self-defense immunity laws of states that don't provide that degree of clarity in their statutes, which is unfortunately most of the self-defense immunity states. And then a third post of this week, which was supposed to go out today, but we had a snow day here today, so our work schedule is a little crazy. But it involves the popularity and dangers of defensive display statutes. So this is something that's of increasing popularity among various states. There's a concern among legislatures that while the actual use of deadly defensive force is pretty clearly delineated by justification laws, self-defense, defense of others, defense of property, there's less structure around the mere threat of deadly defensive force, the mere display of a gun, for example. And it's not uncommon for aggressive prosecutors to go after people who've displayed a gun defensively as if they've committed aggravated assault with a firearm, which is good for a 10 or 20-year felony. So states have increasingly been trying to pass statutes that make clear that, hey, if it's a legitimate defensive display of a gun, there ought not be criminal sanction for that. In fact, that's a good thing. That's a social policy we want to advocate because it provides an intermediary step before actually having to shoot the attacker, right? If you can deter the attacker by a mere display of your lawfully carried gun, well, that's better than someone having to get shot in order to stop the attack. But they also want to protect people who make a defensive display, a legitimate defensive display, from the catastrophic financial and maybe life-changing, if they're convicted, consequences of being prosecuted for that defensive display. Unfortunately, these statutes are often quite ambiguously crafted, or their application would be very ambiguous. That's not a criticism of the legislatures writing these defensive display statutes. I think it's really hard to write an effective defensive display statute that doesn't run into really confounding factors in the messy real world of use of force. So we're exploring that in this blog post, which will probably now go out today or sometime tomorrow, given that we're doing the news and Q&A show today. So if any of that's of interest, if that's content you'd like to see in more detail, and it's all very law-based content, so it's based on actual law, statute, court decisions, jury instructions, but all translated into plain English. So if you have the interest of having a professional's level understanding of use of force law, then you might consider becoming a law self-defense member. As I mentioned, it's extremely, extremely inexpensive. And even better yet, you can try it out at no risk, actually negative risk, by becoming a trial member of Law Self-Defense for just 99 cents for 2 weeks. If you decide you don't like it, just ask for your money back. We'll give you 200% of your money back. So negative risk, and you get all the access you would of any standard member at Law Self-Defense during that trial period. You can learn more about that at lawselfdefense.com/trial. Okay, so now let's jump into our questions. We had a number of excellent questions sent in today for today's show. And again, just as a reminder, you can send us questions anytime at show@lawofselfdefense.com, and we'll certainly consider them for a future news and Q&A show. So one of the questions that would send in is defense against either defense of yourself or defense against a third person against multiple unarmed robbers. This is from Joe D., one of our platinum members at Law Self-Defense. He lives in the San Francisco Bay Area, and apparently there's been a substantial increase in the number of attacks by unarmed robbers. So you're in a subway station, for example, and you're surrounded by 5 or 6 people. None of them display a weapon. But they want your cell phone, they want your wallet, they're demanding all that stuff. And of course, there's obviously an implicit threat of violence if you don't provide that material. So what do you do to defend yourself against this type of scenario? Now, I'm sorry, apologies to Joe. I'm actually not going to answer this question this week. I'm just kind of setting it up because Joe was kind enough to provide a video to an example of this kind of robbery. Unfortunately, I got this question too late to spool up the video for today's show, but in next week's news and Q&A show, I'll do an analysis of that actual video. So I'll share the video with all of you, and then we can step through the really complex dynamics of defense against multiple unarmed robbers. And the legal framework for this is relatively straightforward. I mean, it's not complicated. It's the usual 5 elements of self-defense. But the real world dynamics get complicated because of the absence of a weapon, because if you do defend yourself, for example, with a gun, everyone's going to run away, and there aren't going to be multiple unarmed robbers standing around while the police are interviewing you later after you've waved that gun around. So it becomes your word against speculative counter argument against you. You'll be admitting, and other witnesses will say, hey, that guy waved a gun around. You're going to say, well, it's because of those multiple unarmed robbers. Well, where are they? Because they're not there when the cops show up. So we'll talk about that in more detail next week, along with the video of an example of such an mob unarmed or multiple unarmed robber scenario in next week's News and Q&A show. Martin H., who happens to be from Guam, sends us an email. It's kind of a complicated email asking about the use of pepper spray in self-defense, more complicated than we can get into really comprehensively. That's the kind of stuff we cover in our level 1 full day course, is the use of non-deadly force in self-defense and the legal parameters around that. In particular, the use of OC spray, which I give some emphasis. But in closing, Martin also asks if there's any duty of care if you've incapacitated someone. So you've used force against someone defensively. Let's presume it was lawful self-defense. But now you've caused them some incapacity or some injury. Do you have a duty of care to provide them? So you've pepper sprayed them, or you've shot them, or stabbed them, or whatever the case might be. They've suffered injury because of your use of force. Do you have a legal duty of care? Now, there is such a thing as a legal duty of care. It's a thing that exists usually in one of 2 contexts. So you don't have a generalized legal duty of care. If you see someone drowning in a pond, you may think the moral right thing to do is to swim out there and rescue them, and perhaps so, but there's no legal requirement for you to do that. In other words, if you don't do it, you're not guilty of any crime. There's particularly not a legal requirement to do such a thing if it would create jeopardy for yourself. And for those who don't know, rescuing someone who's drowning, especially if you're not trained in how to do that, is a high-risk endeavor. But in any case, you don't have a generalized legal duty of care, generally, to the public in general. Where you can have a duty of care is if there's a special relationship between you and the person needing the care. This can happen if there's a custodial relationship, say a police officer in custody of a suspect, or a school teacher in loco parentis custody of children, or a nurse or doctor in custody of a patient. So in certain narrowly defined special types of relationships, there can be a duty of care for one person to provide care to another. Another scenario in which there can be a duty of care is if you've caused the harm that the other person is suffering. So you didn't just happen to see someone drowning in a lake. You pushed them off the boat into the lake, and now they're drowning. There, you have a duty of care. You caused the danger or harm to that person. So under that standard, it would seem to apply to a self-defense scenario, right? If you've pepper sprayed someone or you shot someone, do you have that duty of care to them? Are you legally obligated, criminally legally obligated, to provide them now with first aid or other care, or face legal consequences for having failed to do so? And the answer is probably not, especially if doing so would place you in jeopardy. Now, absent the jeopardy component, maybe you would have a duty to provide care for harm that you've caused. But there's a balancing here, and the balancing is on 2 levels. One is, are you facing yourself jeopardy in an effort to cause harm. So someone's trying to kill you with a machete. You shoot them with your concealed carry pistol. They fall down. They're bleeding. You call 911. You ask for police and an ambulance. Are you now obligated to also approach them, come in contact with them, and provide first aid? Well, the argument I would make is, hey, the only reason I shot them was they were trying to kill me. So that's a person who was just trying to kill me. I'm disinclined to close proximity on someone who was just trying to kill me. I'm not obligated to provide care if providing that care means that I'm creating potentially life-threatening jeopardy for myself. And if the counter argument is, well, yeah, but you're like the guy who pushed someone into the lake off the boat. You caused the harm. I would argue, well, no, I didn't cause the harm, not in any legal sense. The person who caused that harm, legally speaking, was the aggressor. The aggressor compelled me to cause them injury. That's on them, not on me. It was their conduct that was unlawful that led to the injury. My conduct was legally justified as lawful self-defense. Therefore, it's their burden to carry. Now, having said all that, I will tell you that prosecutors love to talk about this in court. If you shot someone in self-defense, even if you called for police and an ambulance, which you should do, by the way, because it helps mitigate this argument by a prosecutor, this risk, this rhetorical risk. Prosecutors love to argue that, hey, this defendant didn't just shoot that child, the child who was committing an armed robbery of you, the 16-year-old. Then he left him there in the street to bleed out and die rather than try to provide some care and save his life. That's the kind of rhetorical, emotionally driven argument prosecutors like to use with juries, especially in marginal cases of self-defense where they think the emotional component might push the jury over the edge to convict you of the murder or manslaughter charge you're facing. And they'll make that argument, especially during closing arguments to a jury. The best way to offset that is to try to make sure that the person you've had to shoot in self-defense gets care. For one thing, you probably want that person to live for a number of reasons. One is if they die, you're facing much more serious criminal charges than if they live. I did this again. Sorry, folks. There I am. If they die, you're facing much more serious criminal charges, murder or manslaughter charges, than if you shot them and they live, where you're probably looking at something at worse, an aggravated battery charge, which can be bad enough given that you've used a gun, but probably is not life in prison without possibility of early release, which is what murder is likely to get you. So you want that person to live. Plus, if you've asked for police and an ambulance, you can at least say, hey, or your lawyer can say on your behalf, look, that person just tried to kill me. I wasn't, I didn't want to shoot them. I had to in order to save my life. I wish it hadn't happened, but I can't create life-threatening jeopardy to myself by trying to approach that person. But I did call for an ambulance so they could get professional medical assistance at the first opportunity. And by the way, folks, when that ambulance shows up, if they know this is a violent crime scene, they don't approach that suspect until law enforcement tells them the scene has been secured. So if they're not willing to incur jeopardy to provide care, and they're the pros, I would not encourage you to be taking on that jeopardy yourself. Dave W. sent a very interesting email. He says he recently purchased a pepper spray device that apparently looks just like a gun. Would it be illegal or unwise to brandish it if a threat seemed imminent but could possibly be stopped with non-lethal force? So there's two separate issues here. One is, of course, the appropriate use of defensive force in self-defense. Pepper spray is appropriate to a non-deadly force attack where you're privileged to only use non-deadly force in self-defense. A gun would be privileged only against a deadly force attack where you'd be privileged to use deadly force in self-defense. Again, that's all around the element of proportionality and a claim of self-defense, the kind of content we cover in our level 1 core class and in great depth. My concern here with this scenario is that the pepper spray container apparently looks like a gun. So it's going to appear as if you're waving a gun around. And folks, that's really, really dangerous. For one thing, if you've been threatened with non-deadly force harm, which would privilege you to use pepper spray in self-defense, but you come out with something that looks like a gun, and that other person who committed the non-deadly force attack against you reasonably perceives it as a gun? Well, what's happened in the eyes of the law, from his perspective, is you've started a second fight. He started the first fight, the non-deadly force fight, and against that fight, you're privileged to use non-deadly force in self-defense, but then you apparently escalated the fight to a deadly force fight, which is a second fight now. It's a new fight because of that escalation. And guess what, folks? He's legally privileged to defend himself against your deadly force attack. Now, you know you're only making a non-deadly defensive force response. But if you pull out something that looks like a gun and he reasonably perceives it as a gun, he's reasonably allowed to respond to it as if it is a gun. And if he happens to have a gun on his person and he draws it and shoots you, and then only later discovers it just happened to be an OC container that looked like a gun, well, that was probably your lawful killing right there in defense of himself against an apparent deadly force threat. Also, if you're waving what appears to be a gun around, well, there's other people around, right? Maybe someone steps in to be a third-party defender of this other guy against what appears to be a deadly force attack. Maybe a cop turns the corner, sees you waving an apparent gun around when there's no apparent deadly force threat you're defending yourself against. There's nobody near you armed with an apparent weapon, because the actual attack upon you might have been a shove, for example, or a thrown punch. And here you have a gun you're waving at somebody. That doesn't look like a good outcome to me. So I would advise against a OC container that has a gun-like appearance for all those reasons. There's good quality OC available in a container that looks like an OC container, and is not going to be mistaken for a handgun under normal circumstances. All right, we've got about 5 minutes left. One last question. John V., one of our Platinum members, asks, many of you may know, I talk about our sponsor, CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. In fact, I'll pop their little graphic back on the screen while I talk about this, so you can take advantage of that offer to get 10% off your membership with them. But John V says, hey, there's states like New York that ban self-defense insurance. In fact, New York State bans most forms of CCW Safe insurance. I think the only one they allow is one particular offer that CCW Safe has for retired law enforcement officers. That's still permitted in New York. But their normal CCW Safe coverage is not permitted in New York. New York doesn't permit most of these coverages in their state. And John asks, how can they do this? How can they ban this? What's their justification? And folks, the only justification is that they can. They can just make it so costly and be so threatening to the provider of these policies, whether they're CCW Safe or anybody else, USCCA, Armed Citizen Legal Defense Network, it's all the same, that it's not worth the cost of doing business in the state. Remember, the people going after these legal service memberships have infinite amounts of money for all practical purposes. They have all the power and resources of the state to drive these companies into the ground unless the companies agree to not provide their policies in that state. So how can they do it? They can do it because they can do it. And that's why. We had another question from somebody about self-defense insurance type policies. They asked about firearms legal protection. This is to my mind, a relatively new entrant. They may have been around a while, but I wasn't familiar with them until they were brought to my attention last week. This commenter on our last News and Q&A show, Top Shot, asks my opinion on them. I don't have an opinion yet. I have reached out to FLP and asked a few preliminary questions. Their vice president of legal operations, Terry Johnson, did get back to me and answer those preliminary questions I have in a favorable way. So far that's encouraging. He did invite me to have a longer conversation with him about FLP, and I plan to do that. And once I have a more comprehensive understanding of how they work, I'll be glad to provide my opinion on whether I think there's something worth considering by any of you for this kind of quote-unquote self-defense insurance type coverage. And you can trust, I'll give you my straight-up perception on that value proposition, regardless of the fact that obviously one of our sponsors is CCW Safe, one of their competitors in the marketplace. All right, folks, just a couple minutes left. Let me see comments here, questions from our members on our membership dashboard. Oh, Matthew's here. He sent me in the inquiry about the defensive display law being passed by the being considered by the legislature in where was it? Alaska. That's where Matthew is. Steve asks, could the Syracuse shooter, this would be the guy who shot his neighbor with the ghost gun and now is looking at 15 years for the ghost gun, could he have a necessity defense? The necessity defense can work for unlawful gun possession cases, but it only applies during the period in which having the gun was a necessity. So if, imagine, for example, this fight happened and the homeowner, the defender, just happened to see a ghost gun laying on the ground while his neighbor's charging at him with a machete. It's not his ghost gun. He doesn't know how it got there. He knows it's unlawful for him to have it, but he's facing the necessity of defending himself against a machete attack. So he grabs the gun, picks it up, uses it to defend himself. That transient period of possession for purposes of necessary self-defense could well be justified under the necessity defense. What can't be justified is if he had possession of it prior to the necessity, which is what happened here. Of course, he already had possession of the gun. So the necessity defense could apply to the transient period of defending himself against the attack, but not to the possession generally. Leroy asks, any comments on the college player bathroom beatdown? I'm afraid I don't know what that is, but I will look into it. If you want to send me more details, email me. I'll look into it in more detail. Now on the Facebook page, hey TC, my buddy TC in the comments. Lots of names I recognize. Thanks, folks, for always coming in. By the way, folks, if you could do me a favor and just let others know, if each of you let two people know about this show and about the replay, open access replay available at lawofselfdefense.com/blog, that would be greatly appreciated. Hopefully you can help us grow the law of self-defense community. Someone asked, they got to today's show late during the live broadcast. Will it be available as a replay? Yes, every one of these news and Q&A shows is available as a open access replay at the lawofselfdefense.com blog. In fact, you can catch all the prior ones too. So hours and hours and hours and hours and hours of prior shows. All right, folks, there's a couple other questions here I can't answer, though, because you wrote them in a particular context, and I'm not seeing them to the end of the show. So somebody asked, would CCW Safe cover this? But that's Mike. Sorry, Mike, I don't know exactly what you're referring to. So too late for me to ask the question now. But in the future, when you guys post your questions, make sure you provide enough context so I know specifically how to answer it. All right, folks, I think that's all I have for this week. We're right at the top of the hour, maybe a minute over, which is fine. As always, please come back next week. We do this every Thursday, 4 p.m. Eastern Time. Don't forget about our very special offer that we have running this week on our Law of Self-Defense core class and our state-specific class. That's $600 worth of our course content we have available this week only for only $150. So you're saving 75% off. That's the lowest price we've ever had on these courses. It's collectively something on the order of 12 to 15 hours of plain English, but expert self-defense law instruction. If you take this course, folks, you will know more about self-defense law than virtually any lawyer you'll run into. This sale is on only until next week's show. So if you'd like to learn more about it, point your browser to lawofselfdefense.com/show sale. One word, show sale, lawofselfdefense.com/show sale. All right, folks, as always, before I let you go, I remind all of you, if you carry a gun so you're hard to kill, that's certainly why I carry a gun, so I'm hard to kill, so my wife and family are hard to kill. You also owe it to yourself and your family to make sure you know the law so that you're hard to convict. All right, folks, I'm Attorney Andrew Branca for Law of Self-Defense. Until next time, stay safe.